Hello, everybody. This is Janelle Stanton. Welcome to our third Tuesday webinar, Getting into the Weeds on FMLA Part 2. Today we're going to be talking about qualifying reasons, employee notifications and employer response, and certification. So as always, this is a very big topic, and I have tried to break things down and into more manageable size pieces, but unfortunately the FMLA is just such a complicated law. So again, we're kind of biting off a pretty big chunk of, let me see if it's hard to hear me. Hopefully, if that person could let me know, is it a little bit better to hear me? Make sure everything is working on my end slightly. Okay. Getting some comments that the volume is very low and that people can't really hear me. I'm going to exit the call and then I'll call back in and hopefully it will be better. I apologize for that. Let me try that. Okay, so I just tried calling back in. Could you please let me know if the volume situation is better? Could be a headset issue. Much better. Okay, great. I'm very sorry about that. Thank you so much for letting me know. So as I was saying, with the FMLA, it is just really difficult to break this down into very neat parts. And so, like I said, today we're going to be biting off a pretty large chunk of information here. And originally I had thought this might be a 3-parter, but it's looking more and more like it's going to be a 4-parter. So thank you again to everybody for attending episode 5 of our third Tuesday webinar. This is the second in our FMLA sort of 4-part series that we've got going on. Today, like I said, we're going to cover qualifying reasons for parenting leave, serious health conditions, and military-related leave. We're going to also be covering employee notification and employer response requirements. And then we're also going to talk about certifications. So with that being said, as always, I do like to touch on a few of the housekeeping items as far as the presentation itself. So with all of our presentations, we do record them. And so if you want to either show this to somebody else in your office who wasn't able to make it, you want to watch it again just because it's so amazing and it wowed you, I will be sending out a recording of the presentation. And also please note, sometimes it does take GoToWebinar a very long time to get these videos downloaded, and so I try to get everything, the email sent out the following day, but sometimes I'm waiting on that recording to get downloaded, so it may be tomorrow or the following day, but I promise I will get it out to you. Everybody who attends and is in attendance the entire time is able to get HRCI credit. So those of you that are SPHR, PHR certified, you will be able to get 1 hour of credit for attending this presentation. As always, I do type up the Q&A that happens. So if you have a question, go ahead and enter that into the question box in the GoToWebinar navigator, and I will, if it's pertinent to what we're currently discussing, I will definitely address it then. Otherwise, I'll wait to address it at the end. I also last month had sent out our FMLA decision tree. I'm going to send that out again, so if you missed it last month, that's the collateral material I'll be sending out. I do have in the handout section a copy of the slide deck if you want that for note-taking purposes. And then the last bit of housekeeping is I always do send out a survey. So it helps us understand how we're doing, if there's other topics that are of interest to you, and helps us always be improving on us ourselves and what you guys are looking for. So we really want to be responsive to that. So if you have a couple of minutes, it's very short. I think it's 6 questions and very non-threatening. If you would like to fill that out, we'll be sending that out in the email as well. Okay, so let's start and get jumped right in because we do have a lot to cover. So what we're talking about this month is some of the qualifying reasons for FMLA. And one of the big reasons is what we call parenting leave. So individuals can take leave under the FMLA for the birth or care of a newborn child and the placement of a child in your home for adoption or foster care. FMLA may also be taken for any pregnancy-related complications. So if there's, if the employee needs bed rest, for example, before the baby actually comes, FMLA can be taken for that purpose because it does apply to a pregnancy-related complication as well. This time off applies to both mothers, fathers, and same-sex couples equally. So mothers and fathers can all get parenting leave under the FMLA if they're otherwise qualifying. This type of leave does have to be taken within 12 months of the birth or placement for adoption or foster care. So unlike other types of leave where, you could become ill and that illness may last for a period of 3 years, for example, where you could use FMLA for that original illness, parenting leave does actually have to be used within the first 12 months of that birth or adoption. Another thing to note with parenting leave is that if both spouses, so the husband and wife, the wife and wife, the husband and husband, mother, father, any combination of that, mother, mother, father, father, I think I got them all. But if both spouses or individuals, parents, are eligible for FMLA leave and are employed by the same employer, that leave is limited to a combined 12 weeks. So it's not like the mother gets 12 weeks and then the father gets an additional 12 weeks, so they're out 24 weeks. They actually have to use that time in a combined period. So that is one unique area where both parents are working for the same company. Okay, I've got a question here. Let me see this. This question is regarding if employers pay 1 month's salary during the leave, does PFMLA pay from the first day of leave or after 1 month that the employer pays? So I think I'm going to need some clarification on this question because FMLA is unpaid. So you get 12 weeks of unpaid job protected leave after the birth of a child. If the company has a policy where they pay for 1 month or they get short-term disability or what have you, that's a completely separate issue, and you should set it up so that those types of leave all run concurrently, so that, because pay doesn't have anything to do with the ability to qualify for FMLA. If there's short-term disability or some other type of paid leave policy, or if the employee has like a bank of PTO hours and they want to use that to get paid, then they get paid for that period of time. But this law is essentially just saying that, this law is just saying that you get the 12 weeks of leave. Yeah, okay, so yeah, PFMLA, no, the whole presentation is going to be FMLA general, so it's not an entire presentation about, parenting leave under FMLA. It's a good question, though. I answer that question a lot. Okay, the next type of leave that we're going to jump into here is leave to care for a serious health condition. And so this type of leave applies to leave that's taken because a serious health condition makes the employee unable to perform the functions of his or her position. or for the employee to care for a spouse, son or daughter, or parent with a serious health condition. So for the employee's own serious health condition, or for the serious health condition of a spouse, child, or parent. And it is limited to those family relationships in the federal sense. So because nothing, of course, with FMLA can just be easy, everything sort of has a definition. So a serious health condition that makes the employee unable to perform the functions of his or her position. Well, what is it considered a serious health condition? So the FMLA considers a serious health condition to be an illness, injury, impairment, or physical or mental condition that involves either inpatient care or continuing treatment. So you're looking at, is there an illness where inpatient care or continuing treatment is needed? So that is kind of the two things that you're going to be looking at. So what is inpatient care? According to the FMLA regulations, inpatient care is an overnight stay in a hospital, hospice, or residential medical care facility, i.e. a nursing home, that includes any period of incapacity. So incapacity meaning they're not able to work, attend school, or perform other daily activities like cooking, cleaning, those types of not able to feed themselves, bathe themselves, those things. So inpatient care is an overnight stay in a hospital or nursing facility. So that's the first prong. Second prong being, so it's either they are receiving inpatient care or they're receiving continuing treatment. And so continuing treatment, of course, this won't surprise you, has sort of its own unique definition of what is considered continuing treatment. So continuing treatment is considered incapacity and treatment that requires a period of incapacity of more than 3 consecutive full calendar days and includes any subsequent treatment or period of incapacity relating to the same condition. And so what that means is they have to have more than 3 consecutive calendar days that they are receiving continuing treatment, and then including any subsequent time. So let's say they have surgery on their shoulder and they are hospitalized or receiving treatment for 3 consecutive calendar days. That is going to trigger your flag as the employer to say, that sounds like FMLA to me. Those 3 consecutive full calendar days, if an employee calls in sick for 3 consecutive full calendar days, you should start thinking about FMLA, because that is going to be possibly considered continuing treatment. One example here that I want to give to just kind of explain this continuing treatment idea and help maybe clarify a little is, so let's say we've got Mike and we've got John here. Mike cannot work for 6 days, 6 consecutive days, because he's got a stomach virus. On the second day that he's sick, he goes to the doctor. The doctor says, hey, there is no medicine for this particular virus. You should go home and rest, eat chicken noodle soup, watch The Price is Right. He saw the doctor once, versus here now John. John has the same condition. He's got the same stomach virus. They probably worked together and, shared a Coke or something. So anyways, John has the same condition. He's out for 6 days. He gets the same advice from his doctor. But John, unlike Mike, who goes home, eats the chicken noodle soup, and watches The Price is Right, John does not accept the doctor's advice, and he ends up going back on the 4th day of his illness to the doctor. The doctor says, hey, you're kind of an idiot. You need to listen to me. Go home, eat chicken noodle soup, watch The Price is Right. So in this situation, the same exact amount of time that they're out, same illness, all of that. Do we think that for any reason one of these is going to qualify for FMLA and one isn't? The answer would be no. John does not have a serious health condition, even though he went to the doctor twice, so a period of continuing treatment, and he's been gone 6 days. And the reason is John does not have a serious health condition because there was no reason for him to return to the doctor the second time. There wasn't medicine that could treat him, and it was all about his failure to take care of himself. That's the cause of the second condition, or the second visit, not a serious health condition. So in this situation, neither Mike nor John is going to qualify for FMLA. If new symptoms had developed, so let's say, we change the facts a little bit. Mike is Mike's taking care of himself, having the soup. But John, he's got this stomach virus that all of a sudden turns into, a flu, or he's, very dehydrated and needs to be hospitalized to, replenish his fluids or something like that. So he's hospitalized for a period of 2 days, 3 days, something like that. In that situation, John is going to qualify because then he does have continuing treatment. But him being a bonehead and not taking care of himself, like the doctor said, is not going to qualify him under the definition of what is continuing treatment. So this can start to sort of feel like everything is going to be considered a serious health condition, except most things are not going to be considered a serious health condition. The common colds, flu, upset stomach, headaches, sometimes migraines, routine dental issues, some of that kind of stuff, that is not going to be considered a serious health condition. However, if complications arise from these conditions, so, going back to John, if because of this stomach virus he became severely dehydrated and had to be hospitalized, well, then FMLA is going to kick in. Similarly here, if you have the flu and it becomes a very serious flu where you have to be hospitalized for it, that's going to be different. But these, a general condition where you're just not feeling well, you might go to the doctor once to get, if you've got, you need to get a root canal or something, and so you get the root canal, you go home, you're recovering from that for a while. That's not going to be considered a serious health issue. FMLA regulations also don't consider cosmetic treatments, like treatments for acne or plastic surgery, to be a serious health condition, even if you go in for, some type of outpatient procedure. You need the next 4 days of work to recover from your facelift, for example. You do not have a serious health condition because that cosmetic surgery, A, was not the result of an illness or injury, and B, didn't require a continuing course of treatment. So in those situations, you may be able to deny FMLA because it just may not be considered a serious health condition. Okay, so if an employee has a serious health condition, then that employee is entitled to take leave if the serious health condition makes the employee unable to perform the essential functions of the employee's job. Does that sound familiar to anybody? FMLA actually has borrowed the meaning from the Americans with Disabilities Act to help employers determine if the employee is able to perform the essential functions of the employee's job. So if the employee has a serious health condition, they've got, a condition that either requires continuing treatment or an inpatient stay, then we look at whether they are unable to perform the functions of their job. And again, this is very similar to the ADA. So here, if, I'll just give a real life example about what I broke my baby toe a couple of weeks ago, and I went in, I had x-rays done. When I was in the airport in Atlanta last week, some very impatient gentleman cruised by me with his big suitcase, and he slammed my toe, and I thought I was going to die. I went back in just to have it rechecked, get more x-rays. So maybe you could make the argument that I've got a medical condition that, I've gotten continuing treatment for, but does my broken toe make me unable to perform the functions of my job? I'm here today. I'm telling you guys all about FMLA and all of its glories. I am able to perform the functions of my job, so I don't need probably FMLA leave in this situation. Now, I would urge you to not substitute your own judgment for that and leave that up to a medical provider through the certification process that we'll talk about later. I would urge you to get certification from the provider, sending along what the essential functions of that employee's job are, so that the medical provider can determine whether that illness or injury prevents them from being able to perform their job and therefore qualifies them for FMLA. Okay, I've got a couple of questions here. What if the employee is claiming frequent migraines that limit his ability to work productively? Yeah, in that situation, if it's a chronic migraine situation, that is definitely can be something that is considered a serious health condition. Just having a headache for a day or so, is one thing, but a chronic migraine condition where they're debilitating and they actually cannot perform work, and they're getting continuing treatment for those, that is often considered to be a serious health condition under the terms of FMLA. And two of you had this same exact question at the same time, so I like where you guys' heads are at. Let's see, would outpatient surgery that is not cosmetic fall under FMLA if they need to be off for recovery? Again, this is going to depend. So, outpatient surgery, if they, don't have like a repeat course of treatment that they have to get because of it. So let's just say, maybe they had a torn rotator cuff and they are, they get that repaired, but they're, there isn't a really continuing course of treatment, although I wouldn't buy that because, you probably need PT or there could be various follow-ups. And so it's going to be something you have to look at on a case-by-case basis, but it is possible that like an outpatient day surgery could be considered a serious health condition for purposes of FMLA. A lot of the reason why plastic surgery and those types of surgeries are not considered for under FMLA is because they're typically unrelated to an injury or illness. And so it's elective surgery. There's not an injury or illness there that necessarily they needed to have plastic surgery for. However, if a woman is going into, she had a mastectomy and then is having a breast reconstruction surgery, obviously in that situation, plastic surgery is related to an underlying illness, and so that is going to qualify for FMLA. So there's just, again, the test about whether and when things are considered a serious health condition has to be sort of analyzed on a case-by-case basis, but, those plastic surgery, elective surgeries, like LASIK, for example, often does not qualify somebody for FMLA, and it just kind of depends on the what is actually happening with that employee, because especially if there's complications, they have to go back, or they have surgery and they need to go in to have PT done, those sorts of things. Certainly that could be a serious health condition. I've got another question here. What about mental health conditions? For example, a diagnosis of PTSD? Absolutely. So if an employee has a diagnosis of PTSD and they're healthcare professionals, so whether that be a psychiatrist, psychologist, medical, MD, if they feel that if the employee has an ongoing course of treatment, i.e. medication, med checks, counseling, those types of things, and they are unable to perform the essential functions of the job, so maybe they need more breaks or they need a couple of days off a week to be able to attend appointments and have breaks and things like that, then yes, intermittent FMLA leave is probably going to apply in that situation where you've got an employee with a diagnosis of PTSD. Again, I would urge you to rely on the medical doctor or physician or healthcare professional's medical certification about, what type of serious health condition do they actually have? What limitations do they have on their ability to perform the job? What, sort of schedule or reduced schedule or intermittent leave situation is going to help them deal with that serious health condition? Relying on the medical certification for that is going to be crucially important. Next question is, what if you have an employee that is out for a week for mental health, change in medication, then next month is out again, over and over? Again, I urge you to rely on medical certifications. And if this is something that's happening over and over and over and you think there's a pattern of abuse, or for some reason you start to believe that there's dishonesty or some type of underlying issue, you can request recertification, or you could get a second opinion from a doctor selected by the company itself. I'm going to get into that again towards the end here, but you have the ability to get that recertified, ask if that is reasonable, that the employee is going to have these medical, these medication changes over and over and over like this. And if the physician says, yeah, look, we're trying to get the medications correct, we're having a hard time, if that if the physician seems credible, that employee has 12 weeks of job protected leave that they can use, assuming they qualify for all of the other reasons. And it's really not up to the company, unless you think there's some type of dishonesty, to say, we don't believe you, we don't think you need this time off. So yes, that could be a situation where you need to get recertification if you're seeing this pattern over and over again, and you have some reason to think that maybe it's not legit. But yeah, you may need to actually continue providing that time if it is something that's needed. And kind of along those lines, touching on substance abuse here, because this is a huge issue in workplaces right now. While substance abuse may be considered a serious health condition, an employee is not necessarily entitled to FMLA leave because they have an inability to work caused by their use of a substance. So if an employee is addicted to opiates, for example, and so because of that use, they're not able to, drive a forklift or work in some safety sensitive role, or even, for example, stay awake at an office job, they're not entitled to FMLA for their inability to work based on the use of a substance. However, very important distinction, FMLA leave may be taken for treatment of that substance abuse. So if you have found that your employee has shown up to work under the influence of opiates, if you're in a state like Minnesota and it's the first time that they have been caught using a substance at work, you can't necessarily just fire them. You would need to allow them the opportunity to go to treatment. And so an employee can take FMLA leave to receive treatment for their substance abuse issues. That treatment does have to be provided by a healthcare provider or by a provider of healthcare services. And you can request certification to prove that that has been happening. An employee can also take FMLA leave to care for a covered family member who's receiving treatment for substance abuse as well. So if it's your spouse, child, or parent, an employee can take FMLA to help their loved one get through substance abuse treatment. Got a question here. We are a staffing company, so when they are placed as a temporary, how do we coordinate? If the assignment is over a year, the person needs surgery and will be out 4 to 6 weeks. How is this handled? A little confusing of a question, but I mean, staffing companies, you should make sure that your temporary employees know that while they're on assignment, so if they've, have been in assignment for over a year and now they qualify for FMLA, you should make sure your temporary employees know that you are the one that they must come to when they have a serious health condition or they think that FMLA might apply or may be needed, because you are still that employee's employer. So they should know that you are the one that they need to go to. I would also hope that your client, so where you've placed your temporary employee, understands that if that person goes to the manager on site and says, hey, I need to have surgery in a couple weeks, that manager then will know that they need to contact you as the staffing company to provide that notice as well. So again, that's a training issue, but just make sure that both your client, their managers, and your temporary employee all understand that any request for FMLA needs to go directly, to you as that employer of record. Great questions, you guys. This is awesome. Okay, so I just talked about the definition of serious health condition and talked mostly about an employee's own serious health condition. But like I said at the beginning, an employee can use FMLA to care for others that have a serious health condition. And this is limited to spouse, son or daughter, so child or parent. The law at this point says son or daughter, but child, regardless of gender identity in that situation, is going to apply here. So if you have an employee come in and they say that they want FMLA because their grandmother has a serious health condition, unfortunately, that's not something that's going to be protected by the FMLA. There may be state laws on the books that would allow the employee to take paid sick leave to care for a loved one's illness or injury, but FMLA, that's only limited to spouse, child, or parent. And those definitions are actually fairly broad. Definition of parent includes a biological, adoptive, step, foster parent. The definition of a child is the same. It includes, stepchildren. It includes children that are what's called in loco parentis. So this is basically what in loco parentis means is it's somebody who has stepped into the shoes of a parent. So for example, if a grandparent assumes the ongoing responsibility for raising a grandchild because that kid's parents are not capable of providing care, for example, that grandparent is essentially going to be a parent and going to be able to take FMLA leave to care for their child. So the definition of who is a parent's son or daughter or spouse, again, is to be construed very broadly. Okay, moving on from our serious health condition purpose of leave, there are two different types of leave that apply to military personnel. The first one is a qualifying exigency leave. And so this type of leave arises out of the fact that the employee's spouse, son, daughter, so child, or parent is on covered active duty, or they've been notified of an impending call or order to covered duty. So in this situation, covered active duty means deployment as a member of the armed forces, and it may be the National Guard, the Reserve, any branch of the regular armed forces qualifies here. Reasons for the qualifying exigency leave, they include short notice deployment. So if somebody's going to deploying on 7 or fewer calendar days, an employee may be able to take leave under this qualifying exigency leave. They can take leave to attend official ceremonies, programs, or events sponsored by the military. So the Marine Corps Ball, for example. Child care and school activities. So if a child of the covered military member needs time off to, change an existing child care arrangement. So maybe the parent that provides most of the child care is set to deploy. So now you're scrambling to try to find a new child care provider, that sort of thing. That is covered under this type of leave. Employees can take leave to make financial or legal arrangements like having a will prepared, getting a power of attorney set up, transferring bank accounts, signatures, those sorts of things. Employees can take qualifying exigency leave to attend counseling. They can take that leave not to exceed 15 days, by the way, but R&R, rest and recuperation. So an employee can take up to 15 days of leave to spend time with a military member who is on short-term R&R leave. They can take the leave to attend post-deployment activities, so welcome home type of things, or unfortunately issues, if a covered family member was killed in the line of action and you need to address issues relating to the death of that member. And then, of course, as well, parental care. So, again, arranging for alternative care or providing care for the parents. All of those are types of activities that are covered by the qualifying exigency leave. And again, individuals that take leave under this provision, they get 12 work weeks of leave, just like every other type of leave. All right, got a couple more questions here. Okay, so I've got a question here. This is kind of jumping ahead into the notice provisions here, but the question is, we have an employee that has been off for over a week and now decides to apply for FMLA because he has a serious health condition. Do we backdate the notice of eligibility? Okay, so first of all, and I'm going to touch on this, but I'll just give it away a little bit because of the question, but if you have an employee that's out for a week, I would hope that you would know why. So if they've been calling in sick for a week, you got 3 days, that triggers you to say, next time that employee calls in, I'm going to find out why. And if they call in and they say something like, hey, I've got, this horrible flu, I've been in and out of the hospital, etc., it is totally the job of the employer to start the FMLA process. So after 3 days of an employee being out sick, that has to trigger in your mind FMLA. If you miss that, because the employee doesn't have to say the magic words FMLA. If the employer, you as the company, have reason to believe they may be out because of an FMLA qualifying reason, you have to start the FMLA process. We're going to get into all that notice requirements and everything like that. I never recommend backdating the notice of eligibility. Unfortunately, you've missed your 5-day time frame, but you're not terrible. So what I would say for this particular employee is the next day that they miss work for the same reason that they've already been gone, then you start the FMLA process from that day. Backdating it just can get a company in just way too much trouble. It's not best practice. So the next day that employee misses, get them out all of the required notices. We're going to talk about all of that, but I would not recommend backdating. The question here is, if an individual has guard duty once a month, can they take the day prior and the day after to rest up under the FMLA under R&R? And so, no, they would not be able to, because they have to have specific R&R orders. So it's not just I'm tired and so I'm going to take a day off ahead and after. That's not qualifying exigency leave. This is for an individual with a family member who's military personnel to go spend time with that family member who has R&R orders from the military. So no, it would not qualify under the qualifying exigency leave law here. It would not qualify. Okay. So we are, getting into military caregiver leave. Okay, so military caregiver leave is different from exigency leave. Military caregiver leave is available for family members of the armed forces and certain veterans, and it actually entitles an eligible employee for up to 26 work weeks of leave during a single 12-month period. So unlike all of the other types of leave, this one is actually going to give an individual up to 26 work weeks. So it is unique in that way. And I'm going to give an example of this that I actually thought this comes from a real case, but I thought was fairly interesting and a good explanation of that 26 work weeks. Because again, that 26 work weeks of leave during a single 12-month period, so in my example here, Julie was deployed to Iraq where she was seriously injured. Her husband, Mike, has already taken 12 weeks of leave in the last 12 months to care for one of their children who has a serious health condition. So he's already gotten 12 weeks in the last 12 months to care for his child who has a serious health condition. So can Mike take additional leave to care for his wife? And if so, how much? So this surprised me when I first read the case. But in this situation, Mike is actually going to be able to take the full, here I've got the answer. He's going to still be able to take the full 26 weeks of military caregiver leave because his wife had a serious injury incurred in the line of duty. So there is you get the 26 weeks regardless of how much has been used for other types of leave. And I understand that in this situation, it can be a very difficult thing for an employer to be able to give 26 weeks plus 12 weeks. But unfortunately, that is the way that the law is written. Okay, so employee notification requirements. I'm going to kind of just start cruising here because we're running a little low on time. So as far as the employee notification requirements, an employee seeking FMLA must give the employer notice of the need for leave. So if the need for leave is foreseeable, they know that they're going to have a baby, for example, employees are required to provide notice 30 days before the leave is to commence. If you have a surgery that's scheduled and you know it's coming up, you must provide, that employee must provide 30 days of notice before that leave is to start if they know about it. However, if the need for leave is not foreseeable, it's an emergency situation, the rules say the employee must provide enough information for the employer to reasonably determine whether FMLA might apply. And so what I'm always recommending is that you have employees use your usual and customary call-in procedures, and hopefully those are spelled out in your handbook, to guide when the employee must provide notice. So if you have in your handbook, a provision that states that the employee must call into a hotline or, voicemail box at least 6 hours, 2 hours, however many hours prior to the start of their shift, the law and the regulations under the FMLA say that it's reasonable for an employer to do that. So make sure in your employee handbook you spell out how that employee is expected to provide notice when the need for leave is unforeseeable, so in an emergency situation. But I will tell you that you can't make those rules so rigid that you then, in an emergency situation, don't allow a little bit of flexibility. I have seen case law out there about an employer who has done something like that, and an employee was in such a depressed, horrible state that they couldn't even speak. They really couldn't function at all. So a family member called in on the employee's behalf. Well, this company said, no, 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 we need the employee to call in. This is not a valid call-in. And then after too many missed days, they terminated that employee because the employee wasn't complying with the call-in procedures. And probably not surprisingly, that employer ended up getting sued and lost. So you can't be so rigid with the call-in procedures if it is an emergency situation. Also, as I have already mentioned, and I won't get into this too much more, but there is no requirement that the employee use the specific words FMLA. If you think you know that FMLA might be at play here, but you're not sure, ask about it. Ask for details. Say, I heard that you have a surgery coming up. Can you tell me what's going on? Remember that old adage, what happens when you assume? I hate that too, but it applies here. If you're not sure whether the employee statements or requests could implicate FMLA, just ask. If you require more information to decide whether their request falls under the FMLA, it is actually the employer's duty to investigate that further. It is not necessarily the employee's job to give you more information unless you're requesting a certification. So if you give the employee a certification document, then the employee is obligated to respond to that. But the employer is really the one who needs to look into that and say, hey, I think I remember this lawyer, Janelle, one time telling me that if I'm not sure, I should ask. We'll ask. Just find out. Okay, let's see. We've got a question here. Okay, the question is here. If an employee has taken vacation a month before, but discovers just a couple days before the actual vacation that they have a serious health condition, would the vacation be valid or should it be canceled and the FMLA apply? If there's been recent case law on this is a great and very timely question. If the FMLA qualifies or applies, so if you're a covered employer and your employee has worked for your company for 12 months and they've got the hours of service and they have a serious health condition, nothing else matters. It doesn't matter if they've got vacation. It doesn't matter if they don't want you to classify it as FMLA. An employer must designate the time off as FMLA, and failure to do so could be considered FMLA interference. So the vacation, it doesn't matter. It doesn't have to be, it can be canceled. It doesn't have to be canceled, but FMLA will apply as long as they meet all of those requirements. And so I would hope that in this situation, if the employee doesn't want to use their PTO or vacation balance to get paid, while they're on FMLA, I would encourage you not to allow that. I would encourage you to say in your policies that PTO or vacation time must be used, in conjunction with FMLA so that they get paid for a little while. So if they have a week of paid time off coming to them, but they're going to take 12 weeks, then they get 1 week paid, and then they have 11 weeks that are unpaid. Pay or not pay, again, is not really a factor here, but I would urge you to state that PTO must run concurrently with FMLA so that you don't have an employee bank up, let's say 6 weeks of PTO and then take 12 weeks of FMLA, so they get actually 18 weeks of time off. That should run concurrently, and making sure your policies are worded that way is super important. Question here, where do you draw the line to not violate HIPAA? You're not violating HIPAA in requesting medical certifications from an employee. HIPAA is a law that applies to, medical providers, so clinics, those types of covered employers. Most employers are not governed by HIPAA, but you are required to keep medical documentation confidential. So the HR or manager has the ability to review medical documentation, but it, obviously needs to be kept confidential. And medical documentation does need to be kept in a separate personnel file from the other personnel folders, again, for confidentiality reasons. So it's not a HIPAA violation for most companies because you're not governed by HIPAA. And yeah, so there is not a violation to that. So does a doctor's notice of illness have to state if the employee is able to work? I highly recommend using the certification form that the Department of Labor puts out because, yes, the doctor's note would need to tell you whether that employee is able to work or not. That's a requirement under FMLA. If an employee has intermittent health issues due to type 1 diabetes, we offered FMLA for the days he misses intermittently. He was provided FMLA paperwork and did not opt to take it. Do I still need to designate as FMLA? Absolutely. The employee does not get an option as to whether they want to take FMLA or not. If they meet all of the requirements to qualify and they have a serious health condition, doesn't matter, tough. Even if the employee agrees, if the employer and employee come to some understanding together, it doesn't matter. You can still get sued for interference by failing to designate that as FMLA qualifying. I just covered all of that. I actually covered that as well. Okay, so let's go over the timeline for employer notice requirements since I'm getting a lot of questions on this. So in every instance, it is the employer's job, the company's job, to, once you have enough information to believe that an employee may have an FMLA qualifying absence coming up, it is absolutely the employer's job to provide within 5 days of either the employee requesting FMLA or the employer having a reason to think that FMLA might qualify, to get that employee an eligibility notice. So it's actually a specific type of notice, and there's, again, the Department of Labor has put out all of these forms on their website for you to have. The eligibility notice has to be provided within 5 business days. So that's the first document that gets triggered, is that eligibility notice. And again, that eligibility is determined at the beginning of each instance. So did they work the 12 hours? Did they meet the 1,250-hour work requirement? That is all part of that eligibility requirement. This doesn't necessarily mean that you are absolutely certain there's an FMLA qualifying illness or injury. That doesn't necessarily mean that. That eligibility notice needs to go out within 5 days, and you can say something like, it's unclear whether this is a serious health condition. We're going to be seeking a certification before you provide the designation notice. That's down the road. But within 5 days of employee request or knowing FMLA may qualify, you have to send the employee that notice of the employee's eligibility to take FMLA leave. There is, combined with that, so each time that the eligibility notice is provided, so every time you send out that eligibility notice, the employer must also provide the notice of rights and responsibilities. And so what the Department of Labor has put out is a combined template called the Notice of Eligibility and Rights and Responsibilities. So I recommend that to ensure you are meeting all of those obligations, you use the Department of Labor's form, which combines these 2 types of notice. So what that means is within 5 days of finding out that the employee might need FMLA leave or the employee requesting it, you're going to send out that notice of eligibility and rights and responsibilities. After that, so you're going to send that out. So if the first time the employee comes to you, you know that they are, let's say you have a pregnant employee that's come to you and she says, you know, I'm going to have a baby. And you don't have to then request certification that she is going to be having a baby or that, you know, somebody's about to become a father, because actually with regard to parenting leave, you cannot request certification of the need for parenting leave. So if an employee comes to you and you know, you can clearly see their leg is broken and in a cast and they're going to need surgery, you may not actually even need to request medical certification. If you know that that employee is going to qualify for FMLA, the employer can provide the notice designating leave as FMLA qualifying right away. So you may not need to wait the 5 days, you know, from your employer determination. But let's say the need for leave is not clear and you need to get certification. Well, if you get certification and that certification makes it very clear that yes, this employee has a broken leg, yes, they're going to be having surgery, and so you now know that that employee is going to qualify for FMLA, you've got 5 days from the date that you determine as the employer that the employee is FMLA eligible to provide the notice designating leave as FMLA qualifying. And I really can't stress this point enough. In all circumstances, it is the employer's absolute responsibility to designate leave as FMLA qualifying and to give notice of the designation to the employee. It doesn't matter if the employee doesn't want to take it. It doesn't matter if you guys have agreed that they're just going to take a couple of days of PTO and come back. Doesn't matter. It has to be designated as FMLA. I have a question about how often can the employer require an employee that's on leave to report his or her status. That is something I'm going to be touching on more later, but we are almost kind of running out of time, so I will just touch on that quickly. What the law says is that you cannot request certifications any more frequently than 30 days. So if you have if your leave is, the duration of the leave is less than 30 days, then you can request it every 30 days. If the duration of the leave is, you know, the full 12 weeks, you can't request recertification at any time during that time. You have to wait until the time is almost up. And so there's just rules on that. You really shouldn't be checking in on the status. So if somebody's gone for 12 full weeks, they're going to be gone for 12 full weeks. You really shouldn't be checking in on their status. Okay, certifications, just really quickly. So the certifications, of course, allow an employer to gather information when FMLA is going to be taken for the employee's own serious health condition, the serious health condition of a family member, military caregiver leave, or the qualifying exigency leave. Again, you'll notice parenting leave is not included here. You are not able to ask for certification that an employee is having a baby, having a child placed within their home for foster care or adoption, or a father going out to on their leave for a newborn baby. So you cannot request certification of that. I know that seems crazy, but you really can't. You do have to give notice of required certifications. So if it is your custom within your company to provide or to require certifications, you should provide employees with a notice of that requirement. And I recommend that that be included in the written rights and responsibilities notice. And remember, you've got to provide that within 5 days. What can be included in the certification depends on the type of leave that's requested. These are not all of the things, but obviously the healthcare provider's information, contact information, the date that the serious health condition commenced, how long it's going to go on for, why the employee cannot perform the functions of the job, if it's military caregiver leave, again, healthcare provider information, whether the covered service member's injury was incurred in the line of active duty, because again, that's a requirement to qualify for caregiver leave, the qualified exigency leave. So this is actually a statement or description that's signed by the employee of the facts regarding the exigency involved. If it involves R&R, somebody already asked about this, but if it involves R&R, a copy of the military member's R&R orders is required in that certification. Employees have 15 days to provide any requested certification unless it's not practicable. So you may need to extend that 15-day period of time if, for example, the certification has to come from a specialist and it's going to just take a month to get into that specialist. You may need to extend that 15 calendar day time period. If they miss it, all the rules say is you've got to provide reasonable extensions and multiple opportunities for the employee to comply. So very important to remember that 15 days may not be a hard and fast rule. Now, if you talk to the employee and they're just sitting on, cooling their heels and haven't been trying to get that certification in a timely manner, then that can, potentially be considered failure to provide certification, and you might be able to deny FMLA until they're able to provide that. So then any absence that the employee has while they're, you're awaiting that certification might be considered unexcused, but you do have to be very, very careful for that. This is the last slide here, just a couple of miscellaneous points. The employee has to pay for costs associated with getting the certification unless it's a second or third opinion. If the certification is not complete, they have to be given 7 days to cure that deficiency. You can require fitness for duty certifications, but you can only do that if it's in your handbook or you have some other type of uniform policy that says any employee that goes out in this occupation for the same serious health condition has to get a fitness for duty certification in order to come back. You can require a second and third opinion if you don't have, if you're doubting or you have reason to call into question whether that original medical certification is valid. And then, again, recertifications can't be requested more than once every 30 days, with some specific exceptions, but suffice it to say that, you really can't be looking to get those recertifications more than once every 30 days. And if the duration of leave is, for example, 90 days, you really can't, you've got to give them that full 90 days before you try to get a recertification. So sorry to be sort of cruising through the end of my material. I kind of thought that may happen. Like I said, just got a lot of stuff going on. We do have a few questions here. I'm going to stay on the line and address those. So if you can hang in here for us, I'm going to answer the questions I've got. If third notice, designation of leave, has not been provided, can an employer issue it late without repercussion? No, there are technical fines within the FMLA that would assess a monetary penalty for being late in providing those designation notices. And if you fail to provide that designation notice and the employee, comes back and wants to sue you, failure to provide designation notice is considered FMLA interference, which is something that a company can get sued for. So the penalties, unfortunately, for failing to provide these notices constitute interference, and you can get sued for that. So definitely correcting that once you know you've missed it is helpful, and it can help mitigate penalties in the future, and hopefully your employee just won't sue you and it will just die and won't be an issue. But if you find an issue, do correct it right away. You can't necessarily prevent any repercussions, though. Okay, let's see. This one's a longer question. We have employees working at different client sites. Often we find that these employees get authorization from their on-site supervisor, and we as the employer are unaware of the absence until nearly a week later when time has not been submitted. In this circumstance, is it acceptable to put the date we found out as the date we were informed, however, the date they went out as the needed leave beginning on the date? That part's confusing, but okay, so this happens all the time, and this is why I'm always advocating for training your frontline managers. They're the boots on the ground. They are the ones who your employee is going to tell, hey, I got to have surgery, hey, I've been sick. Your frontline managers need to be trained so that if they hear something that makes them think FMLA, they either start the FMLA process and paperwork on their own, or they escalate that issue to HR. And the reason being is you cannot backdate that information. So you've got to designate going forward, especially on an intermittent leave issue. So if they've been taking off intermittent days, I don't ever recommend post-dating. So you've got to go from the date that you are providing that designation notice, unfortunately. So yeah, I would say in this situation, you need to be very careful and train those on-site supervisors. I have an employee who just found out he has cancer and will be using short-term disability. Does he have to use PTO first? And do I file FMLA? If this employee qualifies because they have worked for your company for 12 months and the hours of service and all of those reasons, it is almost definitely going to be considered a serious health condition, you do need to start the FMLA process and designate it as FMLA. And hopefully it was recent, because you only do have those 5 days to provide the notice of eligibility and the rights and responsibilities. If you haven't done that, start that now. FMLA has nothing to do with pay. Pay, PTO, short-term disability, all of that is totally different, because it doesn't factor into FMLA in any way. So if the employee qualifies for FMLA, you designate it as FMLA. If the employee was smart enough to take out a short-term disability policy, or they've got a bank of PTO, then great, they're going to get paid for parts or maybe all of the time that they're out on FMLA. But, you know, it doesn't really, they're not correlated or related in any way. And now whether he has to use PTO first, use up the PTO concurrent with FMLA is going to be governed by your policy. So hopefully your policy says that employees have to use up their bank of PTO, before they're able to, at the same time, basically, as the FMLA. So if they've got 6 weeks of PTO and they're going to take 12 weeks of FMLA, they still get 12 weeks regardless, but they're just going to get paid for 6 weeks of that. So you don't say first you use up PTO for 6 weeks, then you get 12 weeks of FMLA, unless your policy is written that way, which hopefully it's not, but they get 12 weeks of FMLA regardless. And if they get paid during it because they've got some other benefit, well, then that's just an extra bonus for them. Follow up, the on-site supervisors are not our employees. They work for the client. Again, training issue. So you're training your employees that, they need to be coming to you as their employer to notify them if they've got a serious health condition, and also notifying your client that their on-site supervisors need to be reporting any illness, any injury to you. That's super, super important. And hopefully your contract also backs you up on that and states that. If someone works less than 12 months but worked 1,250 hours, do they qualify for FMLA? No, that's a two-parter. So they have to have provided 12 months of service for your company and also have worked 1,250 hours. And that was in our first presentation. So if you missed that, feel free to go back to our first FMLA presentation, because I talk about that in pretty detail. How many days does the employee have to turn in the certification portion of the paperwork? I believe I touched on that. 15 calendar days. Might need to extend that, though, if there's extenuating reasons why they weren't able to get it in that amount of time. All right. Any other questions? That's the end of what I've already got here. I'll give you just a couple more minutes. I know we're way over our time here, but these questions are great. And again, will provide a typed up Q&A with the email that goes out. What are the penalties for failure to provide, or so what are the fines for FMLA violations? I don't know the figures off the top of my head. Watch for my written Q&A. I will let you know what those fines are. But you can also be subject to a lawsuit. So in addition to the civil penalties, if your employee brings an FMLA interference claim, depending on how egregious it might be and things like that, you know, we've seen FMLA lawsuits settling for 6 figures. So that is, you know, the fines that are mandated by the Department of Labor, those can be assessed by the Department of Labor, but your employee could also potentially bring a lawsuit, and those damages can get very high very quickly in that case. All right, so it looks like I don't have any other questions at this point. Thank you guys so much again for all the wonderful Q&A. It can make a very dry topic like the FMLA more interesting when you guys are submitting questions, so these were awesome. Again, look for this email from me. I'm going to type up the Q&A that I've received, so you'll get a copy of that along with all of the other things that we talked about. And then look for us. We will be doing our next webinar. I'll get you a date here. That will be on June 18th, and that'll be the third parter of our FMLA series here. So June 18th, we'll be getting out a sign-up sheet for the next presentation here shortly. So thank you so much for everybody that hung in. I hope this was helpful, and hopefully I will see you guys all sign back up next week or next month. Sorry. Thank you. Have a great day.